So the remaining cases also have not been decided yet, but the oral argument took place. The first one has to do with affirmative action. Schuette versus Coalition to Defend Affirmative Action deals with the constitutionality of a Michigan constitutional amendment that was adopted by a ballot measure in 2006 that prohibits race-based or sex-based preferential treatment in public university admissions. And the amendment, again, was passed in 2006 along relatively clear racial lines, so that 9 out of 10 minority voters voted against it, 2 out of 3 white voters favored the amendment. The amendment allegedly has had a substantial impact on minority enrollment at the University of Michigan, including at the law school. The question in the case affects not only Michigan, but potentially 7 other states, as well as other states who are considering adopting such measures. So about 7 other states have similar or identical measures, and other states also are looking at this case to see whether to put such proposals on the table. A similar California ban was upheld by the Ninth Circuit in 1997. So here we have a circuit split, and this is one of the reasons why the Supreme Court granted review in the case. As you know, the Supreme Court, in cases of circuit split, that enhances the chances of a case to be accepted for review. The Sixth Circuit invalidated the Michigan amendment, finding that it was in violation of the Equal Protection Clause. This was an 8-7 en banc decision. The 8 judges in the majority were apparently all nominated by Democratic presidents. The 7 judges in the dissent were apparently all nominated by Republican presidents, just to show the great ideological divide over this issue of affirmative action. The majority relied on 2 Supreme Court precedents from 1969 and 1982 that deal with the very rarely used doctrine, equal protection doctrine, that is called the political restructuring doctrine. The 1969 case invalidated a municipal ordinance from Akron, Ohio, that required that any regulation of real estate that is based on race must be approved by referendum by a majority of voters. This ordinance was aimed at making it difficult to enact anti-discrimination laws in housing, and the Supreme Court invalidated that ordinance from Akron, Ohio. The 1982 case invalidated the Seattle ordinance that made it unlawful for school boards to require that a student attend school that is not the closest school to his or her home. But this particular ordinance also contained 1 million exceptions, none of which pertained to the target of this particular ordinance, which was busing for purpose of racial integration. So it was clear that this particular ordinance was really aimed at taking from school boards only the authority to effect racial integration through busing. And again, the Supreme Court said this is unconstitutional. You restructure the political process in a way that affects the rights of minorities, the ability of minorities to address issues of racial discrimination and prejudice. So in both these cases, the argument that the Supreme Court made was that these are unconstitutional because they restructured the political process in a way that affects only minority rights, and therefore, again, are in violation of the Equal Protection Clause. The argument adopted by the Sixth Circuit in the Michigan case is similar. The Michigan Amendment also restructures the political process, if you will, in the following way. If you are a veteran or you are disabled and you want to get preferential treatment in university admissions, all you have to do is get either some piece of legislation enacted or even by executive action of the Board of Chancellors of the University of Michigan or what have you. But now, if you are a minority student and you want to get preferential treatment for minority status, that was the argument of the Sixth Circuit, you have to get a constitutional amendment. You cannot do it by the way of the regular political process. And this, again, is a unique burden that is imposed on the ability of minorities to attain less discrimination and to remedy the situation that comes out of discrimination and prejudice. And again, the court found that this was unconstitutional. Now, The state of Michigan makes two arguments in support of this, of the amendment and in calling on the Supreme Court to overrule the Sixth Circuit decision. First, it tries to distinguish those two cases, and second, it says, well, if you cannot distinguish them, you should simply overrule them. The distinction is based on the claim that Michigan makes that those two cases dealt with anti-discrimination laws. So what is unconstitutional is in fact to restructure the political process such that it becomes more difficult to get anti-discrimination statutes. But affirmative action is not an an anti-discrimination measure. It is much more than that. It is a form of corrective discrimination. And therefore, the state of Michigan argues this is a different form of a law, the Michigan constitutional amendment is, that is not touched by these two precedents. Now, this is a problematic claim if only because the Seattle Ordinance was a form of affirmative action. It was a busing program that sought to integrate, the busing program sought to racially integrate Seattle schools. And that is not simply banning discrimination. That is something that takes active, affirmative steps to remedy inequality, if you will. So this is the problem for the first attempt to distinguish those cases. The claim would be the Seattle case does not deal with an anti-discrimination law. In fact, the court makes clear that Seattle could constitutionally repeal this busing program. It was under no obligation, in fact, to have it, but it could not do so in a way that restructured the political process as it did. So the alternative, as I said, is for these cases to be overruled. And the argument that is made here is that affirmative action is itself a constitutionally suspect practice. That is to say, affirmative action is the sort of government action that is subjected to strict constitutional scrutiny. In fact, it was given a lifetime of 25 years in the 2003 Guder decision by the court. So affirmative action is itself something that is constitutionally suspect. So it cannot be the case that banning affirmative action is itself a violation of the Constitution. Now, this is a case, therefore, about first principles. This is really a case about whether affirmative action is the sort of action that advances the sort of equality that is mandated by the Equal Protection Clause, or whether affirmative action is a form of action that, in fact, detracts and does violence to the sort of equality that the Equal Protection Clause requires. So this is a very foundational, the reasoning here and the reasoning of the court on this issue is going to be really foundational to the issue of what the equal protection is really about. And the Roberts Court, in fact, the recent tendency certainly would tend to agree with the argument that is made by Michigan that the Equal Protection Clause requires color blindness such that affirmative action is a constitutionally suspect practice, and therefore banning it could not be a violation of the Equal Protection Clause. Let me just add that the Michigan Solicitor General, a rather young Solicitor General, made a terrific job at oral argument, whereas the civil rights attorneys that argued against the constitutional amendment made a lousy job. They really did a poor job of, they botched their argument to the extent to which oral argument matters, which is something that people, of course, disagree about. Justice Kagan is recused from the case because she worked on the brief when it was, she was a Solicitor General at the time that the Department of Justice submitted a brief in the case in the lower courts, but that should not affect the resolution, in fact, because insofar as you have a 4-4 decision by the Supreme Court, the lower court decision simply gets affirmed. So her recusal, in fact, should not affect the outcome. Please.
Okay.